Good afternoon, everyone. I'm so pleased to welcome you back to this second panel for the afternoon. My name's Deborah Epstein. I am a professor at Georgetown. I run the domestic violence clinic there, and I'm on the steering committee of the Gender Justice Initiative that is sponsoring this conference. Panel 2, this is we've called it The Path to Dobbs, History, Ideology, and Race. And as we've been doing throughout the day, I'm going to just introduce each speaker very briefly by name and institution. And I very much encourage everyone to check out their bios, which are unbelievably impressive. We're going to drop a link to that in the chat, but we want to give time to the speakers and time for question and answers. So today we have with us Katherine Franke, who's a professor of law at Columbia University. We have Kimala Price, professor of women's studies at San Diego State University and a member of SisterSong, Women of Color for Reproductive Justice. We have Lupe Rodríguez, who's the executive director of the Latina Institute. We have Dana Sussman, who's the acting director of National Advocacy for Women. We have Deshawn Taylor, who is a doctor of obstetrics and gynecology and the owner of Desert Star Family Planning in Phoenix, Arizona. And we have Robin West, who's a professor of law and philosophy at Georgetown Law School. Naomi is telling me that I said the title of the panel incorrectly, and I did. And I don't have it in front of me. Anyway, we'll roll with that.
You're good. You're good. This is you're doing.
It's been a long day already. I also just want to introduce our two ASL interpreters, who are Elizabeth Bonnet and Leah Acasella. As I said, check out the speaker bios. I am gonna give everybody, I'm gonna unmute myself to give you a heads up when you get to about 8 minutes, to just let you guys know that you need to start to wind up soon, and we'll take it from there, okay? I'm going to start with you, Professor Franke.
Thank you. Thank you, Deborah. Thank you, Naomi, and thank you to all the folks at the Gender Justice Initiative at Georgetown Law School. It's wonderful to be joining you for this really critically important set of conversations, whatever the title of our panel is, which quite frankly, I don't remember either. I sat through the first panel and it was just fantastic and just really wonderful. And so that raised the bar considerably for us. What I wanted to talk about in the brief time we have this afternoon is a little bit what it was like reading Dobbs, both for me, both in the draft and in its final form, which I think all of us listening know were pretty much the same. Because I had the distinct feeling that the opinion structure and meaning were familiar. It rang a bell that was familiar to me. And it then dawned on me after some reflection that Dobbs shares a number of similarities with Dred Scott versus Sanford. Having spent a bunch of time now reading both of them side by side, I've concluded that in important ways, Dred Scott did for white supremacy, defining the United States as a white nation, what Dobbs does for patriarchy, masculinizing the Constitution as a compact among men. What I'd like to do in this short panel, or at least my short time in the panel this afternoon, is read Dred Scott and Dobbs in relationship to one another as cases both about reproductive justice in the shadow of slavery. So first, the similarities between Dred Scott and Dobbs are reflected in their rhetorical structure. Both cases begin with text, the text of the Constitution, and then move to history and tradition. In Dred Scott, Justice Taney begins his consideration of whether Black people could possibly hold the status of citizens within the meaning of Article 3 by looking to the Constitution's text. Now, of course, there are 3 references to slavery in the Constitution. He mentions only 2, the limit on the importation of enslaved people in Article 1 and the right of enslavers to seize enslaved people who escaped to free states in Article 4. Taney makes no mention of the 3/5 clause, interestingly. His reliance on the textual presence of Black people in the Constitution as enslaved beings and thus not citizens is to be contrasted with Justice Alito's conclusion in Dobbs that both women and reproductive freedom are completely absent from the Constitution's text, thus justifying the finding that Roe was egregiously and wrongly decided in 1973. In both cases, the text of the Constitution definitively answers the question of rights and political belonging at stake in those two cases. So both opinions then turn from text to history and tradition, declaring that the viability of the rights asserted must be answered by imaginatively reconstructing and then ventriloquizing constitutional meaning understood by the framers at the time the relevant language of the Constitution was written. Tawney, like Alito, cherry picks colonial history to conclude in terms we're all familiar with, and I think are just too offensive to repeat again here, that Black citizenship was unthinkable to the great men high in literary achievements who wrote the Declaration of Independence and the US Constitution. Alito similarly ignores the significant evidence supporting bodily autonomy and a right to bodily autonomy in colonial history by concluding that history and tradition supports the denial of reproductive rights to pregnant people or all people. Both cases evidence a disdain for the claim of rights alleged, relying on text, history, and tradition to really ridicule the very idea of full citizenship for Black people or women. Interestingly, in Dred Scott, Tawney does so by reference to explicit constitutional text that must be read to regulate the unfortunate race to an inferior civil status, while in Dobbs, Alito does this work by erasing women from the story entirely. The debased presence of Black people in Dred Scott is mirrored by the insulting invisibility of women in Dobbs. So pushing this comparison between the two cases a step further, it's not unreasonable to understand, I think, Dobbs as a case that uses reproductive injustice to exonerate the institution of slavery. Tawney turns to the history and traditions of 18th century colonial and state regulation of Black people to make the point that the term "we the people" meant white people and assigned to Black people a degraded condition as an unhappy race. But interestingly, to make the point, he singles out laws that prohibited interracial marriage and regulated interracial sex, defining the civil status of any children born to parents of different races as necessarily slaves. Sexual and reproductive injustice served as the predicate for and evidence of the notion that in the 18th century, Black people were understood by white lawmakers to be essentially inferior to white people. As such, recognizing Black people as holding any claim to US citizenship was unthinkable, if not ludicrous. In this sense, Dred Scott shows us how the use of white supremacist values to underwrite the regulation of sex and sexuality can serve to legitimize the classification of Black people as an inferior caste under the Constitution. Dobbs, in that sense, is as much about the use of reproductive injustice to dehumanize Black people as it is about the constitutionality of the Missouri Compromise or federalism. So the Dobbs court, I think, can also be understood to consider the constitutionality of reproductive rights in the shadow of slavery in a way that mirrors what went on in Dred Scott. Justice Alito grounds his opinion, at least in part, by referencing state laws in the appendix that regulated abortion at the time of the ratification of the 14th Amendment, or even a little earlier than that, including an 1848 Virginia law that distinguished between free and enslaved people with respect to criminal penalties that could attach to the performance of an abortion. They applied these penalties only to abortions performed by free persons, acknowledging that the criminal laws of the time did not reach enslaved people given that any discipline for their conduct lay exclusively in the jurisdiction of the people who enslaved them, not in the public and the criminal law more generally. Perhaps I think the most telling aspect of the holding in Dobbs that links it undeniably to Dred Scott is the notion that whatever rights, excuse me, people seeking abortion or access to abortion might have, they're to be found in state law and state citizenship, not the federal constitution or federal citizenship. In this sense, both in Dobbs and Dred Scott, the federal constitution is not implicated in or really even concerned with the rights asserted by the plaintiffs. Rather, any rights they might have are a matter of state citizenship. Indeed, both cases declare a kind of hands-off neutrality with respect to the rights asserted by the parties. And remember, Justice Kavanaugh is carrying the water most masculinely or muscularly for the notion that judicial neutrality was required when it came to the question of whether abortion had any constitutional relevance. No, he argued it did not. But unlike his colleague Clarence Thomas, who specifically mentioned Dred Scott in his opinion for the court, Kavanaugh could have borrowed the following language from Taney's opinion in Dred Scott, and I quote, "It is not the province of the court to decide upon the justice or injustice, the policy or impolicy of these laws. That decision, the decision of that question belongs to the political or lawmaking power." Really, that's essentially what the Dobbs court held as well. So in the end, I think Justice Breyer came closest to most clearly connecting the dots between Dred Scott and Dobbs in his dissent in Dobbs when he writes, quote, "Whatever the exact scope of the coming laws down the road, one result of today's decision is certain: the curtailment of women's rights and of their status as free and equal citizens will be part of that scope." So the enduring jurisprudential legacy of Dred Scott, including the way it wove reproductive justice into a larger, reproductive injustice into a larger story of Black inferiority, continues to haunt the court, most recently in Dobbs. As Justice Alito notes in Dobbs, the Dred Scott case was overturned on the battlefields of the Civil War, not by the Supreme Court itself. The white supremacist reasoning that infused every paragraph of Justice Taney's opinion has never been repudiated by the court in the way that Plessy's reasoning was disclaimed in Brown versus Board of Education. So the enduring afterlife of slavery, mixed with the values of heteropatriarchy, form the backdrop against which restrictions on the reproductive health of people who are pregnant in Mississippi have been degraded and were fought out in the Dobbs case. Of course, it's well known that Black women are the most directly and negatively impacted by the Mississippi law that was at issue in Dobbs. Of course, Black men bear the ongoing burden of the afterlife of slavery in this country as well. But when Dobbs is read against the enduring legacy of Dred Scott, it's abundantly clear how those legacies are uniquely written on and through Black women's bodies. Thanks.
Thank you so much, Professor Franke, for that fascinating comparison between the cases. I want to, before I introduce the next speaker, just say that first, we'll hold a little bit of time when the speakers are finished to give the panelists some time to respond to each other. And then we're going to turn to audience questions. So as you come up with questions while people are speaking, please post them in the Q&A function, and I'll keep track of them, and we'll get to as many of them as we can. And our next speaker will be Kimala Price.
Hi, good morning, everyone, or actually it's good afternoon, I guess, for the rest of you, but it's good morning for me. Thanks for having me. And also I want to apologize for keeping my camera off. Apparently my internet decided not to behave today at this time. So it'll be better for me just to keep my video off so I can actually still be, sort of on the call. But in terms of sort of giving my sort of brief remarks, and so I'm a political scientist who studies the reproductive justice movement as a movement, as a theory, as a practice, and so forth. So it's been interesting to me, sort of the conversations that I've been having with people sort of before we got the decision, when it was still being deliberated, and then sort of in the aftermath. And just sort of seeing the ways in which people have been talking about this, but when I've been talking about it, my sort of constant sort of theme that I keep going to is we have to remember the most vulnerable people in our communities, the most vulnerable communities, the most marginalized communities in this scenario. Because to be honest, even with Roe v. Wade intact, abortion was always an elusive sort of right for many people, particularly people of color, low-income people, people in rural areas. You know, they've had difficulty obtaining not only abortions, but other reproductive health services, whether it's because they live in states that have all sorts of restrictions that make it difficult, like waiting periods, mandatory consent, parental notification and or consent, or they have insurance policies that do not cover abortion services, or Medicaid plans. As we know, at the federal level in many states, those plans don't cover abortions, or they live in communities, counties, states that don't have clinics or have very few clinics, again, because of a lot of times of the sort of harassment and violence a lot of providers have to endure, and so many, you know, are not located in certain areas. And so that meant many people would have to travel somewhere else, maybe into not just another state or another part of the state, maybe to across lines to another state, which again makes it difficult for many people. That is a deterrent because they don't have the money or the time and the resources to travel long distances to get these services. But also a thing that still strikes me about the conversations that we're having around this is people are still using the term choice. And from a reproductive justice framework, choice is just not a good framework to be using when we're talking about stuff like this. Because as many reproductive justice activists and scholars argue, you know, its choice is inadequate for addressing the historical and the current inequities, practices, and policies that have affected the ability for marginalized communities to make decisions about their reproduction, their sexuality, and their overall well-being.
We're having trouble hearing you. You may be frozen. I can't tell. Kimala? I'm not sure what the best thing is to do here.
Can you hear me now?
Yes, we can hear you now. Okay. Sorry. We lost you. You were just starting to talk about the context for choice versus justice and systemic oppression. Right.
And so they said, you know, choice is inadequate for addressing the historical inequities, such as systematic sterilization of women of color and immigrants, punitive welfare policies that affect low-income people, environmental racism, immigration policies, homophobia, mass incarceration, and so it goes on. And so the argument is that we have to look at abortion in a broad continuum of services for people of color and sort of other reproductive and sexual health issues that are of concern, such as unplanned pregnancies. There are, you know, high rates of unplanned pregnancy, and some communities still have, you know, lack access to contraceptive services. We do know African-American women and Native American folks have higher rates of infant mortality. We also know that African-American folks and Native American folks low income.
Go ahead.
Me now?
Yes.
Okay. And so they're also the most, the African American and Native American folks are also, I was going to say, poor women of color are also the most likely to be arrested for and prosecuted for homicide, manslaughter, child endangerment while they're pregnant. And so there are a lot of issues that we also need to address with Dobbs, because what's happening with Dobbs, what's going to happen with Dobbs is that we're going to see a lot of these inequities actually exasperate. This is only going to get worse. It's only going to get worse. And as we see more states, applying the trigger laws where they're banning abortions, it's going to be more difficult for folks, and there are going to be folks who are not going to be able to travel. As we know, pre-Roe is always those who had the resources who were the ones who were able to access abortion services because they could travel to another state or to another country to access those services. But also I just want to remind people in terms of we need to think about this more broadly, and what the reproductive justice framework does is that it does that. And so I just kind of want to reiterate sort of the definition that SisterSong uses in terms of us thinking about how to think about sort of reproductive freedom. It's not only the right not to have children, but it's also the right to have children, the right to raise the children that one has in healthy, safe, and sustainable communities, the right to bodily autonomy, but also to add what other folks who've been working on this also would add, the right to decide the conditions of one's pregnancy, labor, childbirth, and postpartum, the right to sexual justice, which means things like having the right to engage in adult consensual sexual activity, the right to one's sexual identity and gender identity, the right to form the relationships and families of one's choosing, no matter what the method is, including things like reproductive technologies and so forth, or the right to marry, or the right to adopt, and so forth. So we have to think about this more broadly. We have to use a more intersectional lens in terms of how to think about this and the impact. And I think Clarence Thomas's opinion really sort of struck a chord in terms of what is really going on in terms of this, because what his opinion pretty much highlights that this is not only just about abortion. And it shows us how connected reproductive justice is to other issues. Because he talked about, now that we've overturned Roe v. Wade, we also need to look at other decisions like the Griswold versus Connecticut, which made contraceptives legal, amongst married people. And then we later on had another case that made it legal for single people. He talked about the Lawrence v. Texas case, which, outlawed, sodomy laws. He talked about Obergefell versus Hodge, which, made same-sex marriage legal. And so this is, I think it's really interesting that he pretty much revealed what the right is thinking about doing, that they're systematically sort of chipping away at a lot of the rights that we have gained over the last 50 years. And really, it is about sort of creating this sort of white supremacist, heteronormative, patriarchal social order where you have sort of white cis male men who are still in control, who are still in power, who are controlling everyone else. And so we need to push back against this. And it's not, and I don't think talking about choice really gets at it, because choice doesn't really adequately address the connectedness of abortion and contraceptives to all these other issues where we're talking about mass incarcerations and pregnant people who are being shackled while they're giving birth, for example. Or when we see that folks who are being detained in immigrant detention centers, that they're still being systematically against their will. And so I kind of want us to keep these things in mind as we're talking about Dobbs. We should not forget about the most vulnerable and the most marginalized communities. And so that's all I have to say. I think my time is up, actually.
Perfect. Thank you so much for persevering despite the tech issues. And I think I hope we have a lot more to say about politics and language choice, and the major political implications of that on the panel. Thank you so much for that. Our next speaker is Lupe Rodríguez.
Thank you so much. First, I want to say that I'm so grateful to be on this panel, grateful and honored really to be on this panel with such incredible counterparts in the movement and in various aspects of law and other things. And thank you to Georgetown Law and the Gender Justice Initiative for the invitation. I'm Lupe Rodríguez, Executive Director of the National Latina Institute for Reproductive Justice. And I want to just start by sharing a little bit about the National Latina Institute. We go by Latina Institute for short. We are an organization that has national presence as well as a state presence that centers the voices of Latinx community members to change the narrative and transform systems in our country that have never served us and that really have determined and kept us away from being able to have full bodily autonomy. Our work, is done by building an activist space, by shaping policy, and by shifting culture to fuel a larger reproductive justice movement. And so, just as Professor Price mentioned, we work through a reproductive justice framework to address societal inequities and intersections that affect the folks that are most impacted, frankly, by all of the kinds of laws and bans that are going into effect, and that have always been vulnerable communities that have always sort of faced the most difficult barriers to be able to have access to care and to be able, again, to, because of that, have not been able to have full bodily autonomy. We also, as mentioned, we're a national organization. We have chapters or programs in states where we do some deep organizing work. So we work in Florida, in New York, in Virginia, and in Southern Texas. And there, we're working to build power, amplify Latinx voices, and organize and have advocacy presence in the states as well. We're working to really create a future where pregnant people no longer face the barriers that I've mentioned to access reproductive health care, and where we can see all families thrive no matter how much they earn, who they are, or where they're from. We're doing this again by building a pathway for activists to build and recognize their power and play an active and central role in creating a country where we have true reproductive freedom. I want to start today by sharing a little bit about the national abortion ban that was introduced by Senator Graham this week. As a way of sort of introducing the fact that, this bill demonstrates that the intent of anti-reproductive rights politicians and activists is not just about banning abortion. I think, again, Professor Price mentioned this already, that there is a long-standing agenda in this country to continue to create obstacles and barriers for those most vulnerable, who've been communities of color, low-income folks in this country, to be able to have access to care and real access to reproductive health care and abortion, and therefore to have access to power. I think what we're seeing with this legislation is also that any kind of conversation that existed leading up to the Dobbs decision about how these politicians wanted to give the right back to the states around abortion is not true. Of course, this shows that the ploy is to ban abortion across the country, and that's kind of movement forward that we're facing in advocacy right now. All of this despite the fact that poll after poll has found that the vast majority of people in our country, including Latina and Latinx community members, want abortion care to be legal and protected. We understand that abortion care is an integral part of having economic security, having opportunity, and recognize that we need access to this care. And so we know that these restrictions are going against the will of the people. One of the other things that I wanted to share about is that, a little bit more about how these bans disproportionately impact Black people, Latina and Latinx people, Indigenous people Asian Americans and Pacific Islanders, people with disabilities, and members of the LGBTQ plus community. You know, for a long time, our communities have faced structural barriers that have placed us at a significant disadvantage when seeking care, including less access to jobs with a just salary, paid days off, insurance coverage, affordable housing, childcare, the ability to get, you know, to leave work to get care, or other kinds of space to be able to do that. And you know, these bills, while and this ban, frankly, with Dobbs, while it doesn't, in a lot of ways, materially change the way that folks are able to access care, because for many people, care has been out of reach for a long time. It still was at least a bare minimum protection for our communities, and we no longer have that. And of course, we've found that in places where abortion is essentially completely gone, like in Texas, there are like the barriers that have always existed for folks to be able to move around and to get care are of course now making it entirely impossible for people. I think another thing to mention is that, you know, for many Latino and Latinx community members specifically, we work multiple jobs that provide no sick days or insurance coverage, as mentioned, and really kind of make those barriers difficult. And then I want to add about our immigrant community members. There has always been a fear of criminalization and detention around, you know, seeking care, around seeking services in general. And certainly with these abortion bans and with the Dobbs decision, we have seen a heightened fear in the community that has impeded folks from being able to get the care they need. You know, one of the other things that is very important for us is that, well, and actually one other thing I'll add is that in immigrant communities right now, you know, what we're seeing is that folks at the border who are undocumented or have mixed status families, who are afraid to move around in the state as it is, because they face internal immigration checkpoints that are north of the border, inside states, up to 100 miles inside states, at major thoroughfares, are essentially locked in to these places that no longer offer care. So in Texas and other border states. And so for them, you know, this idea of being able to move around to another state to be able to get care is absolutely not a possibility or reality. And I think that that's something that we're not talking a lot about in this moment, about the impact of this decision and of all of these restrictions and bans across the country. I want to, you know, end by talking a little bit about some of the other things that we're seeing in this moment, about how, you know, as of right now, 16 states have abortion bans in effect. And we know that that means that 1 in 3 American women now live in states where they no longer have control over their bodies. And we are seeing that there is rampant misinformation in the community around, even in states where there is still access at the moment. We're seeing rampant misinformation that paints the picture that abortion is illegal, that it is keeping people and delaying people in getting care. We're also seeing the, you know, heightened misinformation about criminalization and folks believing that even though there is no law in the country at this point yet that criminalizes individuals for seeking care, there is misinformation that makes that connection for folks and is instilling lots of fear. I think, you know, I'll end again by saying that the fear of criminalization goes far and wide. And I think one of the things that we're really worried about in this moment is, you know, the fact that our communities have always been criminalized. And then, of course, you know, now if abortion care is criminalized and access to it and folks seeking the care, if that's where this is going next, we know that our communities are the ones who, because we have been historically targeted and at risk of being investigated and detained, that we will be part of the first group of people who will be criminalized. And so we're really thinking about that in this moment. How do we, you know, instill in folks the knowledge and power and ability to be able to, you know, live in their rights right now without fear, and fight back against the progression of you know, where we think this might be going in terms of criminalization and other kinds of restrictions for folks across the country. And again, with a special emphasis in looking at the experience, the lived experience that communities of color have always had with criminalization and with detention in general, and then of course with any new opportunity to detain or criminalize people that we will be targeted. And so, again, the Latina Institute is really intent in this moment in ensuring that our communities and again, those most impacted and vulnerable are at the fore of discussions around the impact, that we're also in front in terms of delineating solutions in this moment, and really getting to a point where we're thinking about a long-term picture of what it means to build power so that we can create the systems and influence in terms of political power, in terms of legislative power, and frankly, in being able to have representatives in the court who support the will of the people as it stands in this country. So I'll leave it at that. Thank you.
Thank you so much, Lupe. It's obviously so crucial to remember that context of however draconian, well, Dobbs is pretty damn draconian, but it's landing on a place where things were already so deeply problematic for so many marginalized communities. So thank you for that. Next speaker is going to be Dana Sussman.
Hi, thank you so much. It's really an honor to be in conversation and in community with all of my co-panelists, and thank you to the organizers for pulling us all together to have these important conversations. And I think Lupe really set up my talk or my piece of this beautifully in expressing the ways in which criminalization has impacted communities before 1973, in the years that we had a fundamental right to abortion, and what we can predict for the future. So in order to draw the connection between the right to abortion and broader pregnancy-related criminalization, I'm going to quote from Justice Thomas, who's come up quite a bit in our conversation today. In the Dobbs oral argument, he asked both the attorney for Jackson Women's Health Organization and the Solicitor General essentially the same question. He asked them, he said, "Your argument is about abortion. I'm trying to look at the issue of bodily autonomy and whether or not she, presumably the pregnant person, has a right also to bodily autonomy in the case of ingesting an illegal substance and causing harm to a pre-viability fetus." So Justice Thomas, in this pair, the question that came up twice during oral argument, has already moved beyond abortion. That is, the elimination of that fundamental right is essentially a foregone conclusion in his mind. And he's moving to questioning whether pregnant people have a right to bodily autonomy for, quote, a pre-viability fetus. And I'll return to this, but what he is likely referring to is a South Carolina case that went to the South Carolina Supreme Court in 1997 that established that a fetus is a child for the purposes of South Carolina's criminal laws, and therefore pregnant people who expose their fetuses to some risk of harm, whether it's in that case an illegal substance, could be criminalized. And the Supreme Court did not take that, the US Supreme Court did not take that case up. And that decision remains the law of the land in South Carolina and now in 2 other states. So the criminalization of pregnant people because of their pregnancy or pregnancy outcomes has been happening since 1973. And even before Roe, there is this fiction that before the fundamental right to abortion was established, only providers, and I'm not minimizing that significant harm, but that providers were the target of criminalization. And that's actually not true. Patients or people who sought abortions pre-Roe were also criminalized. But the criminal legal apparatus that existed pre-Roe is nothing in comparison to the mass criminal system and mass incarceration system we have today. So since 1973, we have seen a rapid acceleration of pregnancy-related criminalization. And of course, this does not impact all communities equally. Black women, Latinx women, immigrant women, non-binary folks, young people, people of color generally, poor folks, people in rural communities are most likely to face criminalization. That was true in the early decades after Roe, and it remains true today. And in our work documenting these cases and providing criminal defense on many of these cases, we know that the vast majority of them up until this point have actually involved a healthy birth outcome, in which a pregnant person has been charged with child neglect, child abuse, chemical endangerment of a child, delivering drugs to a minor, presumably through the umbilical cord, because they've exposed their fetus to some risk of harm. But we've also seen many cases involving pregnancy loss, stillbirth, or miscarriage, in which the pregnant person is being charged with a crime because they had allegedly caused the miscarriage or stillbirth, which we know is not grounded in any scientific or medical reality. And then, of course, cases involving abortion outside before Dobbs, it would be outside of the parameters of state regulation, whether it was self-managed by obtaining medication abortion pills from an overseas pharmacy or something along those lines. What we know is that being pregnant transforms conduct that is legal for everyone else in society into a crime because of one's status as pregnant. And what I mean by that, for example, is in most states, drug use is not criminalized. It's possession that's criminalized. But if you are pregnant and you use drugs, you can be charged with crimes like child abuse or child neglect for even merely exposing a fetus to some risk of harm. Often harm does not even need to be established in order to be prosecuted and convicted of those crimes in certain states. Having a mental illness or a disability, having another medical condition, being pregnant, delaying medical care, delaying having a cesarean, if that is one's decision, though that kind of behavior has been criminalized. Engaging broadly in dangerous behavior or being in a, quote, dangerous place. Again, placing one's fetus at some perceived or actual risk of harm brings in the specter of criminal charges in certain places in this country and for certain marginalized communities. The most common scenario we see is pregnancy and drug use, and it has its roots in the calamitous and racist war on drugs. We still see it today. Its impact remains, and it's the blueprint that we know will continue to be expanded. As I said, the charges can include anything from child abuse or child neglect to murder, manslaughter, or feticide. We also see more unusual charges like abuse of a corpse in the context of a pregnancy loss or failure to report a birth or a death. And as I mentioned, the rate of criminalization has been increasing. We captured all of the cases that we could identify from 1973 to 2005 involving pregnancy-related criminalization or other deprivations of liberty, something like a court-ordered cesarean. And we found over 400 cases. From 2006 through 2020, we've identified over 1,300 cases, and that case count keeps growing as we sort of uncover new cases. That does not include 2021 or 2022 yet. So this is a rapid acceleration in the rate at which pregnancy is being targeted under criminal laws. And why do we think that is? And I can only speak for myself, but my understanding or my belief is that it's the rise in fetal personhood, and this concept of fetal personhood, which is more and more at the heart of the anti-abortion movement, and it also is the means deployed to subordinate the rights of pregnant people and criminalize pregnancy. The 1989 Supreme Court decision in Webster included a challenge to fetal personhood language that was part of a preamble to a broader abortion restriction package. And in Webster, the Supreme Court did not enjoin that provision, the fetal personhood preamble. It said that it was simply an abstract proposition, and that it would not be used to restrict the activities of the plaintiffs who were reproductive health providers or their patients. It was merely, quote, precatory and intended to establish a value judgment, and the court declined to issue an injunction. Now, the experience in Missouri, I think, is illustrative. Never before in that state had criminal charges been brought against pregnant people in relation to their pregnancy. And just 2 years after that decision, Missouri prosecutors started to rely on that, quote, values-based language to prosecute pregnant people. And in the years after Webster, we saw dozens of cases in which Missouri prosecutors attempted to criminalize pregnancy. We now have on the books, pre-Dobbs, 11 fetal personhood laws, broad fetal personhood laws that redefine who a person is under state criminal and civil codes, an additional 4 that redefine what a person is under the criminal codes of a state. All of those were passed pre-Dobbs, and it is my sense that they were passed similarly to the ways in which the language around the Missouri provision, a symbolic values-based language, and now they could potentially have transformational impact in their state, really destabilizing impact in their states. If you think about doing a control, find, and replace of person in a state's complete civil and criminal code, to replace person with fertilized egg, embryo, fetus, and person, the impact is really, truly remarkable. And we expect to see, unfortunately, that those kinds of provisions will be used to expand the criminalization of pregnancy. 3 states have already done this by judicial decision. And I mentioned earlier, South Carolina was the first. Oklahoma and Alabama are the other 2. And it's no surprise that those states lead the country in pregnancy-related criminalization. Oklahoma and Alabama being the ones sort of right now very aggressively enforcing their criminal laws with respect to pregnancy. We also know that states will use feticide laws. 38 states have passed feticide laws that ostensibly were passed to protect pregnant people from violence by another person, but have been used to criminalize the pregnant person themselves for a pregnancy loss. And the most recent case that most folks are familiar with is Lizelle Herrera out of South Texas, but there's been cases around the country, including in California and Indiana. So we know that we've got these fetal personhood laws that are emerging in ways that we haven't yet even fully comprehended, and we have feticide laws as well. The last piece I'll just mention is Lupe highlighted this. I think it's really important to reiterate, which is that no abortion bans that have been passed so far explicitly criminalize the pregnant person. On the one hand, that shows that legislatures are not yet willing to go that far explicitly. But on the other hand, my concern is that there are no shortage of existing laws that can be used to criminalize people who seek abortions, experience pregnancy loss, or engage in any other behavior that exposes a fetus to some perceived or actual risk of harm. Before Dobbs, we often relied on the principles articulated in Roe and Casey that pregnant people do not lose their fundamental rights when they're pregnant, and that fetuses are not people under the Constitution in our efforts to defend against these cases. And we, with the exception of those 3 states, Oklahoma, Alabama, and South Carolina, we were relatively successful. We now have to rely on different arguments and different tactics. The conversation in the first panel, many spoke about the ways in which the Supreme Court is counter-majoritarian, that the reflection of our anti-democratic systems and the ways in which communities' voting rights have been undermined reflects our work as well, in that the courts are not going to save us, unfortunately, in many respects, and we have to galvanize public opinion, use responsible storytelling, hold prosecutors accountable. We, of course, have other defenses that we can use in criminal defense cases that we will marshal. We need to bring in more allies, healthcare providers, social workers. The medical and public health community is incredibly important in these conversations, because criminalization harms everyone. The pregnant person, their ability to carry a pregnancy to term, have a healthy birth and connection to their family and community. All of that has really negative health outcomes and repercussions. And we need to build more connections between our work and the abolitionist movement. This is a criminal justice issue or criminal legal issue. And so learning from and building bridges across those movements is critical. So I don't know where I am on time, but I will stop there.
Thank you so much, Dana. I could not agree more. We are going to have to build a much broader political movement from here. So thank you for that incredibly bleak picture of what's happening out there. Okay, next is Dr. Deshawn Taylor. We'll put you on spotlight.
Hello there. It's still morning in Arizona, and I just see so much of us in the previous speakers. We are awaiting a decision next week on whether abortion will be completely illegal in Arizona, or whether we'll have a 15-week abortion ban. So the fear and confusion and the idea that abortion isn't legal right now when it is extremely frustrating. And so for 5 decades after Roe v. Wade, we continue to talk about abortion rights as a woman's individual right to privacy, the individual's right to have an abortion without governmental interference. It was my body and my choice. And that wasn't necessarily wrong. But what good is a right to privacy if pregnant people still cannot get the legal abortions they need, especially poor people and people of color who are most hurt by these restrictions? Siloing abortion care into its own space, separate from other rights, did not help in our fight to maintain our rights to this essential care. How we framed abortion before Dobbs brought us to this place of extreme, uneven, and unfair restrictions on care that disproportionately hurts the most vulnerable among us. In an amicus brief presented to the Supreme Court in the Dobbs case, concerned attorneys, researchers, and others pointed out that, quote, criminalization of reproductive outcomes has devastating, even life-threatening consequences. It prevents people from seeking medical care when they need it, subjects them to cruel and humiliating investigations in the midst of medical emergencies, and consigns them to stigma and condemnation in their communities. Worse, the harms of criminalization are disproportionately borne by people who are already marginalized due to racism, sexism, and socioeconomic disadvantage. People often don't realize that every law passed to curtail abortion access creates opportunities to criminalize providers and pregnant people. As the main institutional contact with these people, our job as medical and medical adjacent providers is to welcome, protect, and help people, not to surveil and potentially criminalize them. We have a moment to meet right now. Roe v. Wade was the floor. Ideally, we would have built upon that scaffold to create meaningful access to abortion care for all. Instead, we got the Hyde and Helms amendments, followed by targeted restrictions against abortion care providers, chipping away at our ability to serve the communities that need us, and essentially regulating many abortion care providers out of existence. Times change, and we can evolve the way we talk about abortion. People are not deciding to end pregnancies in a vacuum. Seeking abortion care is one of many decisions that a pregnant person must make to not only survive, but to thrive. When we talk about whether or not to bring children into this world, we need to talk about lack of childcare, unsafe housing in neighborhoods, food deserts, unreliable transportation, toxic environments, lack of insurance, and so on. And so in the conversations that I'm having with people, I am cautioning that now is not the moment to rush to recodify Roe. Let's envision something better. Because even with Roe in place, it was estimated that 11 million people who could become pregnant live over an hour from an abortion clinic, making legal abortion access impossible due to poverty and other restraints. Since I started providing abortion care in Arizona in 2009, there has been a restriction on abortion signed into law every single year but one, and it is 2022. Let's answer this urgent call to directly link human rights and reproductive rights. Forcing pregnant people to carry pregnancies that are unwanted, unhealthy, and unsafe erases the humanity of the people carrying those pregnancies. Abortion care is healthcare. It's routine and it's common. Abortion care is healthcare if a pregnant person is facing death. Abortion care is healthcare if he wants to finish his bachelor's degree. If she wants to be able to afford to feed the children she already has. Abortion care is healthcare whether the fetus has a genetic abnormality or if the pregnant person knows that their partner is about to leave. Abortion care is healthcare always, because as soon as we talk about it as anything less than the basic human right to care for our own bodies, families, and communities, there will always be someone waiting to step in and make laws in their best interests, or what they perceive to be their best interest, right? And so in adapting a quote from Loretta Ross, the ability of any person with a uterus to determine their own reproductive destiny is directly linked to the conditions of their community. And these conditions are not just a matter of individual choice and access. For example, a person cannot make an individual decision about their body if they are part of a community whose human rights as a group are violated, such as through environmental dangers or insufficient quality healthcare. And so the way forward is to see the human right to an abortion through the lens of reproductive justice. Through the lens of justice, it is the responsibility of the government to create the conditions for its citizens to make decisions based on their lives so that they not only survive, but thrive. So when we're looking at this through a lens of reproductive justice, it's not about policing whether someone should have an abortion or not. It instead pushes us to ask, should a birth occur? Does this specific person in this specific situation have the ability to raise this specific child? Should it be born? And the answer depends on focusing on the broader life and situation of everyone involved. Can we find people healthcare, childcare, a living wage? If they're bringing a disabled child into the world, will we support them in raising that child? Can this particular hospital provide for this particularly medically fragile child? Or are we too far away from the advanced technology and skilled practitioner care that this particular child will need? And so when these are the questions, then the answers become clearer, right? So let's ask ourselves, what type of policies could we create if we shined a light on people's actual lives and how those lives could be re-envisioned within a framework of a value-led society? Thank you very much. I look forward to the discussion that will ensue.
Thank you so much for that, Dr. Taylor. And we are now going to move to our last speaker, Professor Robin West.
Unmute.
Kyle. There.
Okay, thank you, Deborah. Dobbs raises two questions for me. First, what does it mean? And second, what do we do? So on what does Dobbs mean? I want to focus my comments on the court's view of liberty, that is the liberty protected by the 14th Amendment's Due Process Clause against state action that might infringe upon it. What is the content of that sometimes protected liberty? The court is quite clear on what it is not. First, it is decidedly not liberal or individualist in any sense. It is not, for example, the liberty of the individual to formulate one's own view of the good life and act on it by one's own lights. That's the conception of liberty largely relied upon by the court in Casey. This Dobbs court aggressively belittles this understanding. Even more clearly, it is not the individual's liberty to use or not use one's own body as one sees fit. It does not include, for example, the liberty to treat one's body as a shrine, or the liberty to adorn it with piercings and tattoos, should one so wish, or the liberty to give it over to maternity, or to breastfeed babies with it, or to alter its birth-given sex, or to test it athletically against the best of the best, or to open it up to the gifts of pleasure, sexual and otherwise, or to refuse to do so, or the liberty to use it so as to nurture fetal life, or to protect it against invasion by unwelcome and unwanted fetal life, or the liberty to give birth through it, or the liberty not to, or the liberty to control its pains by ingesting drugs, or to use it in such a way as to end one's own life. Physical autonomy or bodily autonomy, as law professor Megan Boone argued some while back, is not within the purview of the liberty protected by substantive due process, even though spiritual autonomy often is, and decisional autonomy sometimes. So if the liberty protected by substantive due process does not include any of that, not decisional autonomy probably, and certainly not physical autonomy, what does it include? The court's first step is clear. The liberty that is protected by that clause of the 14th Amendment against precipitous state action, perhaps an overzealous legislature besotted by liberal ways of thinking, is the liberty to behave in ways that are in accordance with tradition. One might, that is, if other conditions are also met, have a right to tradition-sanctioned behaviors against legislation that might seek to criminalize them. Thus, what I call the court's Burkean, that's B-U-R-K-E-A-N, conception of liberty. As Edmund Burke would have counseled, it's tradition, not ideals of autonomy, whether decisional, physical, or otherwise, that provides the content and indeed the point of our liberty. So the reason the court was wrong in 1973 to find a right to abortion in the US Constitution is that there is no such tradition of legal abortion dating back to the Reconstruction Amendments or to the 1700s or to the 1300s. Rather to the contrary, there's been a steady procession of male jurists for close to a millennium, pronouncing its criminality in exquisite detail through changing views of quickening, of quasi-felony murders, secondary and primary intents, varying degrees of blameworthiness and of homicide, and so on. There's no tradition protecting legal abortion, so there's no liberty. What there is a long tradition criminalizing it, so well then. Exactly what behaviors, though, and ensconced in what traditions might be thus protected? Again, just to stress, the court did not have to answer that question to find that legal abortion was not one such tradition, but we can speculate. Remember, the Burkean conception that equates liberty with tradition goes hand in hand with originalism. Put the two together, and what follows is that the traditions central to the liberty that the court is happy to protect are the traditions of a time marked by deeply patriarchal institutions and beliefs. as the court's recitation of the authorities on which it relies makes vividly clear. So what behaviors, sanctioned by what traditions, might such a court recognize as central to liberty? Might liberty, for example, protect the tradition of masculine authority in the household? More precisely, does it protect those behaviors based on the tradition that a man's home is his castle? Does it protect the assaultive behavior of husbands ensconced in the tradition of legal chastisement, so long as the instrument used by the husband to inflict it on the wife does not exceed the width of one's thumb, as per 19th century tradition? Does it protect rape within marriage, which was legal until well into the 1980s, on the ground that that assaultive behavior is likewise embedded in the traditional understanding that a wife's duty is to submit to her husband's sexual advances, and that her withholding of herself, of her body, or of her sexuality is a sin that far exceeds the sinfulness of a husband's infidelity? Does it protect employment practices, likewise grounded in a traditional understanding that a woman's place is in the home, such that she can and should be barred from trades and professions, and when she works, all she really needs by way of compensation is pin money? Does it protect the broad swaths of behaviors grounded in the tradition that holds at the point of marriage is procreation, or that a woman's consent to marriage at the altar constitutes lifelong consent to marital sex, regardless of her desire or her will? And what might these behaviors and the traditions that ground them be protected from on this Burkean conception of liberty? Well, perhaps they are protected against 20th and 21st century legislation that would upset them. Legislation, for example, that might grant women a right to protect their physical integrity against the intrusion of an unwanted pregnancy, or legislation that might grant a woman the right to protect her body against assault or rape by her husband, or legislation that might extend the right of marriage to same-sex couples, or that might protect teens who seek out gender realignment, or that might give women access to paid labor and equal pay for equal work, and so on. All of these actual or potential contemporary laws run up against the weight of countervailing traditions of the 19th and much of the 20th century likewise, most of them mightily so. The Constitution, in short, on this view of what liberty is and isn't, doesn't only make the criminalization of abortion constitutional. It doesn't only remove the constitutional shield, it also provides a constitutional sword. It protects traditional patriarchy against the intrusions against it of legalistic and liberal feminism, of virtually all feminist, all queer, all gender conscious goals that might be backed by law. That's one relatively unnoticed takeaway of all that Dobbs dicta, at least jurisprudentially. My examples of the rights that might be protected by the liberty prong of the substantive due process clause are, I hope, a reductio ad absurdum of a tradition-bound Burkean understanding of liberty when it's yoked to an originalist jurisprudence. I don't believe the court will actually go there. I don't believe the court will create a right of husbands to chastise or rape, or of employers to underpay or refuse to hire, although it might well give would-be fathers and plenty of others a right to force a woman to give birth. But this much is not a reductio at all. The Constitution, given a Burkean understanding of liberty, yoked to an originalist interpretive method, could empower culturally conservative courts to strike progressive legislation that aims to penalize behavior firmly grounded in traditions, and it would do that all in the name of protecting liberty. And this we also know to be true. Patriarchy is as close to the core of our traditions as it is possible to be. We may not have a tradition of legal abortion, but we very much have a tradition of unequal pay, of forced sex and marriage, of forced labor and birth, of chastisement in men's private castles. Feminism of the last century has marked as complete an upending of those patriarchal traditions as anyone could possibly have imagined. So please take seriously the possibility that the Constitution expounded in Dobbs, bound jurisprudentially to originalism and substantively to tradition, and that now governs us, is unequivocally at war with feminism. This newly rediscovered Burkean Constitution is not something that can be interpreted this way or that, as sometimes a foe and sometimes a friend, as a springboard for a field of litigation in which you win some and lose some. Au contraire, a Burkean originalist constitution protects precisely the traditional ways of life that first, second, and third wave feminisms have all sought to upend. So what to do? First, I would say just beware, be wary. The Constitution is legal snake oil. It is not going to help. It's going to hurt. So stay away from it. Feminist gains, when they come, will come politically through state and federal legislation. They will not come constitutionally through litigation. But second, it by no means follows from any of this that we should abandon the idea of establishing a fundamental right to reproductive liberty, but we should pick the target here wisely. The right that will be meaningful, transformative, and lasting, I believe, will be a civil right to reproductive justice, won politically, not a constitutional right won through courts. We might, of course, sometime in a pretty distant future, regain this constitutional right to an abortion through some unforeseeable combination of Herculean effort and seismic changes in the court's personnel. But if we do, it will be badly compromised and constantly at war with the originalist and Burkean constitution that is always already there, by which I mean it always lurks. A civil right, by contrast, is the product of a cultural awakening, in turn recognized by ordinary politics. If I had to define it, I would say that a civil right is a right backed by ordinary law that facilitates a flourishing life in our contemporary world. The construction of a civil right to reproductive justice or liberty, I believe, should be our goal. Societally, I think we are now in this election season undergoing or undertaking the beginnings of an education in the absolute necessity of reproductive liberty, including, but not limited to, abortion access, to women's ability to flourish and to live good lives. With that predicate in place, an educated public, we could then work politically toward crafting law that protects it, a law or group of laws that will protect our civil rights to control our reproductive lives and bodies from start to finish. Our right, that is, to have sex of any sort or not, to conceive new life or not, to gestate and birth or not, to mother or not, and then to thrive and to flourish whichever way we so choose. Thank you.
Thank you so much, Robin. Kyle, I think we'll bring all of us back together now, if we can, onto the screen. And I want to give panelists a moment to take a moment to respond to anything that you'd like to, that another panelist said, before we start turning to audience questions. Anybody have any points that they'd like to make building off of what someone else said? Yeah, Kimala.
Yeah, I just want to reiterate what I think believe was Dana had said about coalition building, because I think that's important. And I think that's something that hasn't been stressed enough within sort of reproductive politics, is that we can't go about this as a single issue, sort of movement, that it has to work with across other movements. And what we've seen in various places, particularly like in California, a lot of our success in terms of pushing back against things like parental notification and consent for teens is that reproductive justice organizations were working across movements and bringing in civil rights organizations, bringing in labor organizations and so forth to push back against this. And I think moving forward, we need to do that as well with this. And what other panelists have said, we have to look at how lack of transportation can be an impact, this lack of this funding in general, finances, financial stability, how all of that is connected to this, and that we need to, at times, as organizations, have to move and work with other movements. For example, I served on the Planned Parenthood board here in San Diego for several years. And one of the discussions that we had amongst our board, and for me in particular, some of us on the board, along with staff members, pushing our board to say that we had to support an initiative to raise the minimum wage here in San Diego to $15 an hour. Some board members thought that wasn't necessary because that's not what Planned Parenthood does. But we were like, we have to, because this impacts our communities, the people that we don't push against for this, then what does that say about us as an organization and what we think about the communities that we serve? And so I just want to reiterate the importance of coalition building. And that's also something I do in my work.
Thank you so much. Deshawn? Deshawn.
I really appreciated the comment about choice no longer serving us. I yesterday just gave a talk on being unapologetically pro-abortion. And I think that it's really important that we understand that language matters. The narratives that we create and we move forward matters. I mean, the anti-abortion forces have been at this for a very long time, and they've honed the way they talk about things and the emotional strings that they pull with certain ways that things are discussed. And so, you know, we have a large swath of the population that, yes, believes that the decision to have an abortion should be a private one between the pregnant person and whomever they want to involve in their healthcare provider. But we also have those same people who do believe that there should be some restrictions, you know, like I'm pro-choice, but, you know, why are people using abortion for birth control? I'm pro-choice, but why is that person having an abortion at 30 weeks? I'm pro-choice, but, you know, why wouldn't a person continue a pregnancy and place for adoption, right? And so we've all heard these things. I'm pro-choice, but why don't people just use birth control? So that, you know, the narrative of choice is very problematic, and it creates this idea of a good versus a bad abortion. And so I really challenge people to move yourself from this pro-choice rhetoric to a place where you are unapologetically pro-abortion. Whether you would have an abortion or not is irrelevant to someone else's decision to have one. Why do you care so much about someone else's pregnancy? And so I think that when we're moving away from this kind of punitive idea of individualism and thinking about holistically as a community and how we care for each other and make everyone's lives better, then we have to start to understand that, you know, part of what we need to do is be leading from values and not judgment, and understanding that people make different decisions about anything in their life, depending on what is put right before them in that moment in time when they're making the decision. Understanding that should conditions be different, a different decision may have been made. And so,
yeah, thank you so much. I do think that there's a theme that came out here and in the previous panel about the importance of language in the political movement here. And when we're talking about choice and leaving out systematically oppressed people who don't really have meaningful choices, Robin West and I were talking in between the panels about language of sex positivity and sex without meaning, the ability to have sex without negative consequences, being linked to the right of abortion leaves out people who are coerced into sex, and that is their big concern. And Dana is also talking about building bridges across from the abolitionist movement and the feminist movement, who often use terminology that are at odds with each other. And so I think that is an incredibly important part of building a political movement here that brings everyone in, is language and framing. So thank you all. I'm sorry, Katherine.
I actually had questions for the panelists, my amazing colleagues on this panel with so many wonderful ideas. One, go to just pick up, I think, something that I think all of us agree with, but some of you articulated specifically and so clearly, is about a reproductive justice, not just a reproductive rights frame. And I'm wondering where you would advise we start in building that as a better legal, constitutional, or political framing for what's at stake here than the horrible liberal framing of choice, sort of a negative rights that we had in Roe, which I think was not a kind of ruling that any of us would have chosen had we been asked. So where does that work start, and how does it begin to be legible in courts, to courts? And then Robin, oh, you're giving up on the Constitution entirely. So I'm assuming that's the second best given the current population of the Constitution or members of the court. Is that true for all fundamental rights and significant issues that I think we would care about, or only reproductive rights or sexual justice? And secondly, if we turn to a civil rights agenda that's enacted through legislatures, can we really avoid the courts? Because the people will challenge those statutes and take them to the court, to courts at some point. So I'm wondering if it's possible to escape the shadow of the Supreme Court, even if we pursue the path that you're suggesting. So I'll stop there.
Can I jump in on that first question that Katherine had? I really think it's important to connect with and follow the lead of organizations that have been at the fore and front of reproductive justice movements and organizing and have employed the framework in all of the strategies and execution of work. And I see that, one of the things that Dr. Taylor mentioned, being around language use and around sort of movement in changing the way that we're discussing this issue in the settings where we lead and occupy space, I think is a really good way of having an intersectional framework and employing some of the tactics and strategy that have been created by the reproductive justice movement. And then just in terms of working together, I know that I will say, I do think it's very important to ensure that we have strategies that are specific to ensuring that we are responsive to litigation, right? Like that there is focus there, that we ensure that like there's movement forward in the courts in protecting these rights, in thinking about like creative ways to solve those problems, and we need those minds there with folks who are in that field. But where we think we can, again, with language, but I also think in terms of just connecting with folks who are doing movement organizing and who are looking at the picture on the ground, the effects of this on real life people, like bringing those kinds of stories to bear in the processes that y'all are affecting, to really kind of bring the experiences of people to the fore in the creation of the briefs and other kinds of things that are going through the courts. I know that we as an organization have been involved, for example, with Hellerstedt versus Whole Women's Health back in, what was it, 2015, in supporting and sharing stories and having folks like talk about the lived experience and effect of that. I think that that's a way to connect on this. And then as mentioned, like thinking about how the organizing that's happening on the ground can be supportive of what we're all doing. I think we can't exist or we can't get to real sort of justice and bodily autonomy if we don't work together as a movement, and if we don't ensure that there's equal kind of like support and representation for all of the different strategies that need to be employed in order for us to get to the liberation and the justice that we seek.
Robin, can you talk a little bit about your abandonment of the Constitution and anything else you want to say? And then I just want to make sure I work in a few of the audience questions too.
Okay, I'll try to be quick. Yes, I'm skeptical of the Constitution in toto, and not just this particular court, not just this particular lineup. I think that we have ill-served the cause of reproductive justice by over-reliance on constitutionalism, and not just because of the bad current personnel. On the broader reproductive justice issue, I really want to underscore, I think, Deshawn's point that the support that should be accorded the abortion right, I think, has to be unapologetic, but it must also combine with rights that are equally unapologetic and robust regarding all reproductive decisions, including the decision to mother. And so the reproductive justice, the part of the reproductive justice agenda that I find so exciting is the insistence that this is about reproduction writ large. It's not just about one person's decision to go get an abortion. It's about the ability to live good lives that are safe and rich and full and fulfilling and flourishing wherever one might be on the reproductive spectrum. And on constitutional skepticism, back to that for a second, I am completely, 100% sympathetic, for example, to the argument that these rights should and could be embraced by a wide-reaching jurisprudence that focuses on the 13th Amendment, right? I mean, that is completely convincing to me. I understand it to the bone. It makes sense. Okay, it makes sense, particularly given the history of slavery, given the history of reproductive constraints. All of it converges nicely. But can you just imagine the backlash if we shift away from 14th to 13th Amendment and start talking about reproduction in terms that resonate with 13th Amendment values? You're going to get hit with the argument that the group that is most like slaves are unborn persons, and that it will just trigger yet another round. The general point, I think, is that I don't think there's any magic bullet constitutional language that's going to turn this around. It's just not out there. It's got to be based on a political movement. It's got to be based on a political movement that has at its heart the narratives of actual people faced with dire circumstances often, but that need access to health care, including abortion care. And I said that I would be quick. The irony of courts refusing to acknowledge bodily and decisional autonomy, right, as a component of liberty, given the fact that the Reconstruction Amendments came out of the Civil War, is just overwhelming. I mean, it just hits you right in the gut. But nevertheless, it's where we are, and it's where we've been now for quite some time. I don't see that turning around, frankly, in our lifetime. And so, yeah, I'm skeptical pretty broadly. As far as other rights go, let's save it for another day. But I would just caution against court-focused and constitution-focused strategies. I think that the suggestions that have been made about how to move forward are all pretty much on the same page of trying to do something that's a little more from the ground up and a little more inclusive of the voices of an awful lot of people. And that what strikes me about that is that it's a politics that's being described. On your last point, Katherine, of course, one must be attentive to the need to defend these things in court. I'm not saying that we could just go hide under a rock as soon as they get challenged. There always will be a place for lawyering, right? And for good lawyering in the defense of these rights. But the origination of them, I think, has to be political. There's a difference between having to attend to constitutional arguments when one is forced to, and just being seduced by the whole atmospherics of constitutional romanticism.
Ouch. Okay, let me read one of the questions that is in the Q&A. And I think, Dana, we might at least start with you because we're coming to the end. This is from Veronica Faison. She says, I'm wondering what folks think about mens rea concerns, re traveling across state lines for abortion. Is it in the realm of possibility for lawmakers to criminalize forming the mens rea of obtaining an abortion in an anti-abortion state, even if they've actually received the abortion in a state where the abortion remains legal? What are safeguards against that? So we're moving to something a little more concrete. Dana, can you talk about that for a minute?
I'm going to preface this by saying that I am no expert on interstate travel issues with respect to criminal law.
Not
yet.
Not yet.
I hope I never have to be, but I think that this is a place of wild speculation and uncertainty. And, I think what we want to emphasize is that there is no law yet that criminalizes the pregnant person for in any of the abortion banned states. And that any law, I think there have been bills introduced that have gotten a lot of attention, that haven't really moved, that have faced extreme backlash when they have been introduced, that contemplate these types of things, but that they will face robust challenge. And I do think that there's always the possibility that prosecutors will experiment with applications of criminal laws for which they were never intended to be, in ways that they were never intended to be applied. That is always a possibility, but I'm taking to heart very much what Lupe has said around the fear of criminalization, some of it exceedingly valid. I mean, that's the work that we do at our organization, but also not wanting to contribute to an atmosphere that makes it even more difficult for people to access information and care. So I think it is possible. I don't see it as an immediate concern in the way I see some of the other possibilities that I laid out, but I'll leave it there because I know we're short on time.
Yeah, we are at time. So I am going to thank all of the speakers, Katherine, Franke, Kimala Price, Lupe Rodríguez, Dana Sussman, Deshawn Taylor, and Robin West. Thank you all so much for being here, and our interpreters as well. Really, thank you so much. This was mesmerizing. This whole day has been both depressing and energizing, which was what we were hoping for, I guess, is some balance between the two. Really, really appreciate you all being here. Everyone, we are going to stop now and resume again at 2:30 where you can sign in for the Zoom link to the third panel. So we will stop now and see you all then. Thank you so much.
Thank you, everyone.
Thank you.
Thank you.